Well, good morning to all of our viewers and for those who are listening in. We welcome you. Uh, this morning, we're going to have a serious conversation about housing and how it has been affected by COVID-19. Many of us know that we've had issues with housing even prior to COVID-19, and this pandemic has exacerbated the situation. And we have some topics that we're going to talk about this morning. And I have with me a brilliant attorney who is well versed in this topic, and that is none other than attorney Jeff Hussey. I call him Jeff, but I know his real name is Jeffrey. But Jeff, can you please begin or just welcome us as we begin this conversation on housing?
Great. Thank you, Commissioner. And I applaud you for getting the information out to your constituents because, as you said, there were already problems in housing before COVID-19, and COVID-19, I think, has just exploited them and put them all under a microscope. So more people are experiencing those problems, and we want to make sure that people understand their rights, that they're not taken advantage of by their landlords, and just want to give you a preview. It's not a pretty preview, but what's going to happen down the road. And we want to make sure that everyone is protected and they understand their legal rights. You do have protections under Florida law. We don't want you to be taken advantage of by landlords who may not want to abide by the law. And I work for Community Legal Services Mid Florida. We are a legal aid society. Our services are free to those who income qualify. We're out there to provide equal justice to people who would otherwise not have access to that justice. So I thank you for having me on, Commissioner, and we can kind of start filling in the blanks for people, hopefully.
Okay, and great. And I'm writing a little note here that before we end this session, that you will definitely give the viewing audience, the listening audience, your information, your phone, your email,
Absolutely.
because they might have questions that they don't want to ask, publicly. And so just remind me before we end that I'm going to ask, well, we'll need your information so we can contact you or they can contact you. But I wanted to begin, and I wanted to talk about what does a renter need to know, or a homeowner during this COVID 19 crisis? Like, what are some of the key things that they should know as a renter or a homeowner?
Sure. There are a couple of things that some people might be confused about because you hear about the CARES Act, you hear about moratoriums, all these things that you might hear on the news or on social media. The CARES Act does provide certain protections for you, but those protections only apply if you're in some type of federally funded housing or have a federally backed mortgage. So there is a moratorium that's been extended to the end of August for federal properties under the CARES Act. But if you are in a private landlord-tenant relationship, then that's when this moratorium that you've heard about that our governor has put into place comes into play. And the moratorium basically just means that at the present time, a landlord does not have the ability to go into court and formally file the eviction and to try and have you removed from your housing if you've not paid your rent. So those are the two big distinctions. Right now, there is a moratorium on evictions in the state of Florida until July 6th. Now, moratorium is not the same thing as I don't have to pay my rent. And that's where some confusion has come up. People say, well, they can't evict me, therefore I don't have to pay my rent. You're still responsible for your rent. You have signed a contract with your landlord to pay a certain amount each month. What the moratorium does is putting off any potential eviction for non-payment until right now it's July 6th. So when July 6th comes, and if that moratorium is not extended, then you are responsible for every period that you did not pay your rent. So if you lost your job or you were furloughed and you're trying to rely on unemployment and you just can't make ends meet and pay your rent, when that moratorium is lifted, you're going to be responsible to your landlord for all the back rent that is owed. And if you don't pay it, then they can go to court and have you evicted and removed from your housing. So that is our concern. And the concern we have too is landlords are getting frustrated. Many people have not paid their rent for several months, and you cannot be evicted from your house without going through the court process. And landlords tend to not be patient, and they're going to take their own way to try and force you out of your housing, and that is totally illegal.
Right.
So,
So we've seen that because you have landlords who, even though they know that this moratorium is in effect, that they're still, I mean, they're still attempting, they're still sending eviction letters, they're still sending notices. There's, some people are saying they're trying to change the locks. You know, I've heard they remove doors, they're turning off water. So we know that the landlords are, going to extreme measures, trying to force tenants to pay, but tenants are realizing their rights. So if someone does get their water turned off or the locks are changed, like what do they do if they know that the landlord is doing something that is out of the realm of what they're supposed to do, knowing that this moratorium is there?
well, the fancy thing that we try and call that is called a self-help eviction. And this was involved, this was pre-COVID-19. Under Florida law, there are what's called prohibited practices. And what you described are several of them are prohibited practices. Landlord cannot come and change the lock and lock you out if you haven't paid your rent. The landlord can't turn on your water off because you haven't paid your rent. The landlord can't shut your utilities off because you haven't paid your rent. Those are all called prohibited practices. And what you can do, and if your landlord does that, is that gives you some additional legal rights. You can do this pro se, or you can call community legal services. We can help you, but you can file an action against your landlord who has done those types of things against you, and you can actually recover damages up to 3 months of rent if your landlord, for instance, has turned your power off. And you would go in front of a judge, and the judge could say, that is a prohibited practice, and basically they're going to punish or penalize your landlord up to 3 months rent. So you do have remedies, but you have to do it in the right steps. And that's why we encourage people to try to call community legal services, or you can go to our website and there's self-help information on there. But know your rights, protect your rights. And we want landlords, we all are governed by law. And just like you can't break the law if you're a tenant, the landlord can't break the law just because they're the landlord. So we encourage people to call. We want to know about those type of prohibited practices because they could even be potentially violating your civil rights if they're only turning off the power to people of color and not white residents. Then that is a civil rights violation under the Fair Housing Act. And we can assist people in filing a federal claim against a landlord who might be discriminating based on the color of skin or your national origin. Same with the other thing, Commissioner, I hate to bring this up, but it's occurring out there, is the bad landlords are sexually harassing female tenants. Single
Wow.
moms who can't pay their rent. So a landlord could come in and say, I got a way you can pay that rent off. That is sexual
Mm-hmm.
harassment. That is a violation of the Federal Fair Housing Act, the Florida Fair Housing Act. It's a civil rights violation. The Department of Justice has a strong push to prosecute those types of cases, and those it's horrible, and that's something I know it's not an easy topic for some people to come forward with, but um, strongly encourage people to come forward if they're a victim of sexual harassment in their housing, because that is it's disgusting.
Yeah, it's
I'm
very.
sorry to use that kind of language, but it just truly is.
But that's the reality. So sometimes you got to let people know, this is what's happening. And maybe it's not happening in your circle, but you have to be aware, because you just don't know. But I wanted to talk about another thing that, we tell people that you should talk to your landlord and tell them, what your situation is. But I always tell folks, put it in black and white, put it in black and white, put it in writing, because you might have a conversation today and somebody might say, oh no, you didn't tell me. So when we talk about telling, communicating, as an attorney, what do you agree? What's the best way that tenants should communicate with their landlords?
Absolutely. I mean, communication, that's a big key, especially in this day and age. But as a lawyer, I love it when a client comes in and can show me a trail of emails or letters they sent to their landlord, because that is evidence. He said, she said, well, I told him this and I told him that, and they told me this. Very much may be true, but getting that to be admissible in court and that being evidence to prove your case can be difficult. But communication is key, especially if you've been affected, your income's been affected by COVID-19, and you don't want to wait until this moratorium is lifted and then for the first time say, hey, guess what? I've been furloughed by Disney and I'm not going to start getting a paycheck until July. What can we do? I just think it's a better practice to start that conversation earlier with your landlord. Send them an email saying, dear landlord, says, I've been furloughed for the past 2 months. That's why I haven't been able to pay rent, but I've been called back to work, so I'll be having a steady income. I'll be able to pay rent going forward and would like to work out a way to pay my back rent.
Right. And that also applies to those who have a mortgage,
Absolutely. Mortgage, that's something else that obviously has been affected. And back in 2008, when we had the housing crisis, there's two different ways when you have a mortgage. There's called a deference and a forbearance. You don't want to enter into an agreement with your mortgage holder and say that, okay, I don't have to pay my mortgage for 3 months, and then on that fourth month, you have to pay 4 months of back mortgage payment. What you want to do is called forbearance, where you could put the months that they've agreed that you don't have to pay at the end of your mortgage. So you can just, once you get your job back, you can start paying as you normally do. Because that's what happened in 2008 is all these people had these deferments, and then 4 months down the road, they don't have if they had the mortgage payments, they would have been paying those 3 months. They don't have 4 months of mortgage payments. And we do have some slides that kind of go through the process. But once again, what you said, communication. If you've fallen behind on your mortgage, you need to call out to your mortgage holder and try and start the process now of getting that forbearance so that the payments can come at the end of your mortgage, not become due in 2 months or 3 months.
Right. So let's go back to the previous slide and let's talk about some points that maybe you missed on as to the evictions. And I guess those who are viewing can actually see the chart, the flow chart that you have.
Okay. What I like, many people hopefully have never been exposed to the eviction process. But I'm afraid a lot of people are going to have some first time eviction process services coming up. One, as I said, identify what type of property that you live in. If it's a government-backed property, then different sets of rules apply, and that's why we would encourage you to call us because we can look all that information up. But this is how a typical eviction would occur, and this is the only way a landlord can legally get you out of your housing if you have a rental agreement with them for non-payment of rent. There are other situations, but let's stick with the non-payment of rent. You have not paid your rent, the moratorium is lifted. What the landlord has to do first is they have to send you a letter. It's called a 3-day letter. And in that letter, they're going to say, you owe X amount of dollars for this period of your rent. If I don't receive it in the next 3 days, then I will start the eviction process. If they don't send you that letter, they immediately can't go forward. I mean, if they go forward, your case can get thrown out. So they send you that 3-day letter. Then the next thing they have to do is they have to actually file what's called an eviction complaint with the court. They have to pay a filing fee and whatnot, and then they have to get a summons served, and the tenant has to get served with the summons of the complaint. That's a key date, and that's when we strongly encourage people to contact legal aid, legal services mid-Florida. If you can afford an attorney, you call a housing attorney because You only have 5 days to file an answer. And if you don't file in that 5-day, case over. You're going to be evicted. But you do have a limited amount of defenses, and you do have ways to challenge an eviction. Most of it is on process. If they have not attached the right things to the complaint, if they have not followed all the proper procedures, then there is the ability to possibly get the eviction dismissed. But what that is doing is just buying you time. Because if you've not paid your rent, there are few, if any, defenses for non-payment of rent. You've entered into a contract with the landlord to pay X amount of dollars, and you're in default of that contract. But if you do go through the court system, that still is not the final step. They have to get a judgment against you, meaning if you haven't answered, they're going to get what's called a default judgment automatically. If you had defenses, then you would have a hearing. But once a judgment is entered against you, what's called a writ of possession has to be issued. And that's when once that's issued by a judge, and only can be issued by a judge, that's when a sheriff is going to come and post it on your door. And that is critical because then you only have 24 hours to leave. Unfortunately, we get calls sometimes after they've received that writ. And there's, we can try and file emergency motions to stay the writ, but the chances of prevailing of those are not good. And you have 24 hours. I have to tell people that, they may have great defenses, but they didn't get in front, they didn't call us in time. You need to look for a shelter or some emergency housing in the next 24 hours because they can come in.
Yes. We have a question.
Okay.
We have from Miss Bush. She says, can the handouts, or I'm sorry, from Miss Clouden, when there is a hearing to evict a tenant, is the tenant allowed to attend the hearing?
Absolutely. Absolutely. That is your due process right in the state of Florida. But to get that hearing, you have to make sure that you have complied with all the procedural aspects of an eviction. And that means one is if it's for non-payment of rent, you have two options if you want to have a hearing. One option is to deposit with the court the amount of back rent that they say is owed. And it's called the court registry. If you don't do that, then you don't get to have a hearing in front of the judge. The other option is if you think that the amount of money in that 3-day letter is wrong, you have to file what's called a motion to determine rent. And that is something else that Community Legal Services of Mid-Florida can help you with. That means, sometimes a landlord says, well, you didn't pay your rent and the penalty is $50 a day that you haven't paid your rent. And believe me, I have seen landlords try to do that. So they're saying, your rent was $500 a month, and they're saying you owe, $1,500 each month because of all the late penalties. That's when you would challenge that, what's called the motion to determine rent. But if you do neither of those things, and it's for non-payment of rent, a judge is not going to let you in the courtroom. They're going to enter what's called a default judgment. So that's why within those 5 days, if you get served, you need to get some legal advice, or at least go to our website and learn what your legal rights are and what the procedures are.
Okay, great. And then we can move to the next slide because we were actually talking about the forbearance. And I didn't know if you were done going through that flow chart.
Right. And let me, Commissioner, let me also say this, that we have certified HUD housing counselors with Community Legal Services. Once again, all our services are free. You can call us up, and we have counselors that can help you navigate through the process. But this chart, and we'll share this chart with your office. So if any of the listeners or anybody else has questions, they can pull this off, and we have it on our website as well. But basically, as I said, the forbearance is you're getting loan payment forgiveness during a set amount of time. And once that forgiveness period is over, you are responsible to pay your mortgage, but that amount you didn't pay is going to be tacked on to the end of your mortgage. So, if your mortgage is set to expire in January of 2030, it's going to be 3 months later in March or May of 2030. So that is much better than, July 1st, you owe 3 months of mortgage payments. So don't go for the deferment. You want the forbearance.
Right.
If you have a home loan, those are two big differences. And just remember forbearance.
That's all you have to remember. The
Yep,
operative
yep.
word,
But
forbearance.
the other thing too is if
And that's
you're
if your mortgage company offers it,
and they're not going to offer it unless you ask them.
Yeah.
You're not going to contact you and say, "Hey, we noticed you haven't paid your mortgage in 2 months. We got some great options." They're just assume wait, and they can file the foreclosure action. And that's once again, if you haven't paid your mortgage, very few defenses. And the defenses you have are more technical defenses. If they didn't attach the right things, and defenses that the mortgage holder can cure. So the forbearance is a great alternative if you can't pay your rent. Back in 2008, we saw a lot of short sales and whatnot. People who couldn't afford their mortgages, and we may be going down that path as well.
Because they had balloon mortgages.
Absolutely. People got into way in over their head, and we hoped, and we hope. I said we hope. I hope that the mortgage companies learned their lesson the first time around.
Well, I think they place so many protections around new mortgages and people who are applying that they made it more difficult, and you had to show more ability to be able to pay the mortgage that you were getting ready to enter into. So I think they did put more strenuous requirements. But when we talk about like landlord tenant issues, a lot of people feel that the landlords have so many protections, and that the tenants really don't have that many protections under the law. And I think we were talking about how people need to understand that these laws are dictated by the state of Florida.
Right.
The legislature sets these requirements and these laws. So can you kind of talk about the importance of being engaged in policy and understanding? I know we're going a little bit off on a tangent, but people need to understand a lot of things that they face is because they're not involved in the policy process of when these things become enacted. So it's very important they stay vigilant, especially now.
Well, here's the thing. I mean, I know we talked about this earlier. Some landlords are taking the position that, well, you haven't paid your rent, I'm not going to fix anything you asked for. If you don't know the right way to do that, people say, well, then I'm not going to, let's say you're paying your rent, but the landlord's still not going to come in and fix things. There's a proper way to do that, and that's called, you have to put them on notice that you're withholding your rent. You have to be active, and you have to take advantage of what's already out there as a tenant. And if those measures don't work, saying that, I withheld my rent and my landlord still has not paid or fixed my plumbing, for instance, then you need to bring that to the attention of people like the commissioner and whatnot. Show, look, our system is broken. I followed all the rules. I'm withhold my rent. I did this, and they still haven't fixed my plumbing. I still don't have, clean water, to show that more protections are needed for tenants out there. But if you remain silent and you don't take advantage of the laws that are out there for you, people in Tallahassee think, well, things are running smoothly. You have to have a voice. You have voices like the commissioner, who you start that groundswell here, and she says, look, this was happening in Orange County and in my district. Fix it.
Yeah.
But you have to bring it to her attention. You bring it to our attention so we can bring it to the judge's attention. But you can't be silent. If you sit back and just take it, say, well, I guess I'll drink dirty water. I don't have any other place to live, so I'm going to just put up with this. No, you do have rights, and you want to enforce those rights that you have. If that's not enough, then that's we're building that that paper trail to show, hey, look, this is the problem we have going on.
All right. And we have a great advocate in the whole the legal services of Mid Florida, because you guys are great advocates. You have the data, you have the information, because you get the client. So I just appreciate the work that you guys do. But we wanted to talk about now some of the resources or initiatives. I know the county before COVID-19, we had a crisis assistance program, but that's limited in funding. Of course, we have the CARES Act funding, which was billions of dollars that was poured into government, local government, and we received $243 million, which portion of that is going towards rental, light bills to help families, and it's only $1,000, and we know that that's really not a lot of funding. And we also had, I think that the government also gave the $1,200 per adult if you qualified, and then $500 per kid. That doesn't go far. And so, are there some resources that when people come to you that you can advise them to go to?
Well, fortunately, on this call is Yesenia, who's with Orange County. The best place that we tell people to do is the first stop is to call 211, which is a United Way, and that's kind of like the gatekeeper. If people just punch 211 on their cell phone, you're gonna get the United Way, and you tell them, where you live, and there are programs available. And, not only what you talked about, some financial assistance, but food banks, emergency shelter, things like that. Unfortunately, we're in a pandemic, and this is first time for a lot of us to go through these things. Hurricane comes and it goes, and this has come and it won't go. It won't go away. But Yesenia, are you on the line? Let's see if we can get her. Yesenia? Okay. All right. Well, hopefully we can get her back on, but
we hopefully we can, but in the meantime,
there's some other questions that have been posted, and so Marissa, you want to share some of the other questions?
Absolutely. So first, we have a question from Miss Clouden. She says, this may be off the subject, but I heard of landlords raising the rent in the heat of the pandemic, even though there is a lease and the lease is not expired. Is that legal?
That is not legal. A lease, if you enter into a lease with a landlord, that is a contract, and that is a binding contract. And the terms for the time period, if it's January 1st, 2020 to January 1st or December 31st, 2020, that is a contract. Both parties are obligated to comply with the terms of that contract. So if they're coming and saying that, I'm going to double your rent now because of COVID or for whatever reason, they're violating the terms of the contract. So what a person would do is, if your rent was $500 before the landlord came to you, now they're saying $1,000, you paid that $500. And if he tries to take legal action against you, you have that written contract, that lease, which is the best evidence. And when I said that motion to determine rent, that's when you would say, no, Your Honor, I have a contract. I only have to pay $500 a month until the end of the year, and I paid my $500. So you do have, that is the case where you would have a great defense. And you can call us at Community Legal Services. I hate to sound like I'm an infomercial, but this is what we work under, various different grants to help people in these situations that can't afford an attorney. So that's what we're here for. And we love to take as many calls as we can and help as many people as we can. So Marissa, next.
Our next question is, if you could maybe explain a little bit more in detail the difference between forbearance and deferment.
Okay.
And then also, if a lender requires all suspended payments to be paid in full, are there any other payment options or negotiating tips that you could suggest?
I'll kind of touch it in a broad stroke, because I don't want to hold myself out as all-knowing in this, but the forbearance and deferment is, the forbearance is you're calling your mortgage. Let's say it's Wells Fargo. You call who has your mortgage. I've been furloughed from my job. I don't think I'm going to be able to pay my mortgage until I get called back, and I would like a forbearance. And they would walk you through the steps. So basically, the forbearance means that, okay, once you do go back to work and you start paying your mortgage, you don't have to immediately pay all those mortgage payments you missed. Instead, those mortgage payments are going to go at the end of your loan. So your mortgage is going to be extended by however many months of mortgage payments they forgave you. They're forgiving the immediate payment, but they're not forgiving you payment completely. Deferment is when they say, okay, you don't have to pay mortgage, you don't have to make any mortgage payments until August 1st. But on August 1st, I expect you to pay all your missed payments. So that's, if you could pay your mortgage, you would pay your mortgage. That's why you're asking for the basic forgiveness for that period. So, but once again, communication. You call your mortgage broke, whoever's holding your mortgage. As for tips, if you can't pay your mortgage, there's it all depends, and I would hate to kind of just throw something out there that may not apply to your situation. But if there's no hope of getting back to the same level of income that you had beforehand, that's when you want to consider, make the hard decision. I may have to sell. You heard back in 2008, there are a lot of short sales, people who knew they were going to go into foreclosure, so they were just trying to get whatever they could to pay off their amount. The best thing I would suggest is to speak with a housing counselor, because each case is different. Each case has unique factual scenarios, and it's not a one-size-fits-all type solution. So you can go on our website, you can go HUD, you can go on HUD's website, and they can provide you with certified counselors who can sit down with you, and they can look at your total financial picture. Some people, are not going back to their same job, making the same amount of money. So, they can put you through a budget and see, okay, is it going to be feasible for you to continue to live in this house and pay the same mortgage payment based on your new level of income? Because what they try and say is you shouldn't be spending more than 30% of your income on your housing. And we know will be awesome, but majority of people are spending much more than 30%. But if your financial situation has changed, there are other options you got to start to consider.
Thank you. And then the final question we have at this point in time is the handouts that we're seeing on the screen, are those able to be reprinted and used by the public?
Well, I'm going to ask you, Marissa, is there a way that they can be attached to this webinar, or do we need to send them to the commissioner's office and then they can she can put them on their website, or they can contact her office?
Sure. They are downloadable as PDFs right now in the webinar. I've placed instructions in the chat if you have questions about that. And I'm also happy to provide them to the commissioner's office as well.
Okay.
Awesome.
And you can also go to our website. We have, it's very user-friendly. And they have, we do more than just housing. I know we've only talked about housing today, but we handle much more than housing as well. So I would encourage, we'll put a slide up at the end about our contact information. If you have a legal issue that we can help you with, that within our priorities, encourage everyone to call.
And there was one thing when we talked about some of our options, or the renter's options, or even a mortgage holder, that you can, if you have a relationship with your landlord, maybe set up some type of payment arrangement, and instead of trying to be faced with having to pay such a huge lump sum of money, that you can definitely, I would hope that, you have been able to communicate with the landlord. You have a landlord who's understanding, and try to set up some type of payment arrangement.
You said a keyword, understanding. We
Yes.
hope, because as we talked about earlier, we're in a crisis, And we were already in a housing crisis even before the pandemic hit. And they're saying right now that the average rent in Orange County is $1,000, and that's a lot of money. But if a landlord has 10 residents who were affected by COVID and haven't been able to pay their rent, if they go and evict all 10 residents, are there 10 people to come in and move in there that can pay the $1,000 a month? Probably not. So, my negotiating tactic would be, look, Mr. or Mrs. Landlord, I was furloughed. My income's going to start back on such and such date, and I'll be able to pay my normal rent payment. I'd like to pay you $200 extra a month, $100 extra a month. You have to do your own budget to see what you can afford to make up for all those periods I missed. And that's when you want to become your negotiator, and you want to say, and hey, to do this, can you waive all those late fees that were tacked on? Just if you don't ask, it's not going to happen. So, what's the worst they can say is no. What's the best they can say is absolutely, I'll waive all those late fees so long as you enter into this payment plan. But you got to understand, and so many people don't, is you are still responsible for that back rent that you didn't pay. The CARES Act, the moratoriums, that's not a magic wand that makes things disappear. Those are an obligation. We talked about that lease when the one viewer was talking about they're trying to raise my rent. Well, that lease is that contract, and you agreed to pay X amount of dollars for X amount of time. Usually it's a 6 or 12-month lease. So you are responsible for those back rent payments. So, become your advocate. Say, I know you hit me with $150 extra each month because I wasn't able to pay my rent. Can you waive that, and I'll enter into a payment plan and pay you, whatever you can afford. Don't say I can pay you an extra $5 a month. That's not enticing to a landlord. That's not. But if you could say, hey, look, I can pay you an extra $100 a month, once I get my job back, that's something that the landlord might consider, because they go through the eviction process. They can get a judgment against you, but there's no guarantee they can get a collection against you. So if you're behind $1,500 in your rent and they get an eviction, they get a final judgment, there's no guarantee that they're going to ever be able to collect that $1,500 from you. So this way, it's more guaranteed money. It's a family in the housing. You appeal to them. You're going to put us on the street if you evict us. But look, we're trying to work with you. But as the commissioner said, communication is the key.
Yeah, I have a question. Something just popped up. If once tenants or landlords start doing the eviction process, do you think that the judges, like in a criminal case where adjudication is withheld, or some type of judgment that won't lock the renters into this whole eviction? Because once you have an eviction on your record, it's hard to move into another apartment. So do you think that the judges will start issuing, or maybe the attorney can request that, yes, I understand I owe this money, I know I have to get out, but I was affected by COVID. Will the judges be sensitive to the fact that, okay, you can say someone is liable without saying, just like you understand?
Yeah. Kind of like
say,
adjudication withheld.
when someone pleads no contest, that means I know I'm wrong, but I'm not going to admit that I'm wrong. So it's like when people plead no contender. So
Yeah.
I don't know if the judges are going to start issuing, where you have to leave, you owe the money, but we're not going to stick you with this eviction that's going to follow you and make it very difficult for you to get an apartment somewhere else.
Unfortunately, Commissioner, unless they have a big change of heart, no. Because the only way they can get you out of your apartment is with that writ of possession. Once again, that may be a situation where you can negotiate.
But what if you agree?
Well, I've had cases where they've gone back after the fact and dismissed their eviction. But once again, that's I guess part of the negotiation. If I lost my job, they're not bringing me back. I'm now working a minimum wage job, which is not a living wage. There's no way I'm gonna be able to afford this, pay the back, or going forward. That's when you maybe have a deal with, you contact your landlord, say, hey, can I just, I got to break my lease. I'm sorry, I can't pay you the back benefit, the back amount of rent I owed, but I don't want you to go through the expense of an eviction.
I
If
guess
they don't file it, then there's nothing there. Because
right.
you bring up a great point, because if you have an eviction on your record, you potentially are jeopardizing your Section 8 voucher. And when you go to move to a new housing, that's the first thing they're going to do, is they're going to pull your history.
Yeah,
And
not only Section 8. I'm just talking about
oh,
a
absolutely, yeah,
renter. But when you go and you try to rent an apartment, and they do background and they check your
credit,
record, and eviction pops up, they're like, you're a liability. They don't,
absolutely,
so,
and
so
especially in the affordable housing arena, when they have a large pool of people to select from, because affordable housing is not abundant out there. Eviction, that's a big strike against you. If you're an equal candidate with somebody else and they have no prior evictions, they're going with that no prior eviction. They're going to see that as a safer choice. And if,
maybe,
it does stay with you, and it's bad.
man, maybe that's something, we can work with the legislature to give the judges some option when someone agrees that, I'm going to leave. I know, I owe the money, whatever, but let me exit out of this situation without having the eviction,
And and and
on my
the, and the only problem with that is it's going to have to take a landlord to agree to it, because to collect, if they haven't paid in 3 months, the landlord needs that final judgment to try and collect on it. So basically, it's almost, the landlord say, okay, I understand, I'm never going to get that money back. So just go. I want to rid myself of it.
Yeah, but even with a final judgment, there's no debtor's prison. No,
No, exactly.
even
And that
with a final judgment, a
it's
landlord is still
uncollectible.
not guaranteed the funding, to get
Yeah.
their money back. So,
And then if they go and try and garnish their bank accounts or their wages, if you're head of household, you're going to get an exemption. And that's something else that people can call community legal services about, is we do handle that, because people do, something I'm concerned about too is, I know a lot of people probably been living on credit, and, they're maxing their credit cards out, and those are going to come due, and credit cards can get a judgment against you, and they can get a garnishment. But if you're head of household, you can, be exempt, but you have to file the right forms. You have to get a hearing. You have to get an order from a judge. So those are other, it's process that right's out there. Most people don't know about that. So that's another reason why, we can try and bring justice to people, equal justice. Call us and we can walk you through it. But I would love to see something like that. I just don't know if it's feasible. Now, the one thing that we don't know yet is, because the courthouses have been pretty much semi shut down, so there is a huge backlog of cases out there, from civil to criminal.
right.
What priority are the judges going to put on the housing issues? I hope it's low on their priority list, because
Yeah.
once again, you can't be evicted without going through the court process. And if the courts are not making a priority to deal with the housing issues, it buys you time. Once again, if you haven't paid your rent, you're only buying time, unless you can work something out with your landlord.
Right.
But
But I hope that we're talking mainly about mortgage holders and renters, but landlords are also suffering. So I hope that when we talk about the communication piece, that I think a lot of this, where the renter can pay something, the landlord is receiving some type of payment. I think that's the best solution.
right,
But it's like you said, both sides have to be willing to agree. I'm hoping that many people will be able to, once even now, or when the moratorium is lifted, whenever it's lifted, that some folks we know are taking advantage of the moratorium, knowing I don't have to pay and I just deal with whatever comes when it comes. But I'm hoping that it won't be as bad as people are predicting. That's my hope.
We can hope, pray. And you bring up a good point. Is I know we've been more tenant focused today, but
Mm-hmm.
landlords have bills to pay, they have mortgages to pay, and they deserve to get paid. If they're renting a room, they're renting a house, they're renting an apartment, they deserve to get paid. I mean, because they need that money to pay their bills. So it's not. This is not the makings of the landlord, because they're just like you and I. They have monthly bills they got to pay, and that's their job, is to collect the rent. So I don't mean to what I'm saying here, saying all landlords are bad and whatnot, because it needs to be a two-way street, and that's why I say appeal to the landlord that this is going to get you at least some money versus taking me to
Right.
court and getting nothing, and
Right.
just at least some money to put towards your bills. Um, Marissa just sent me a note that there's another question.
Yes, thank you. The question is, could you explain the escrow process to withhold rent due to non-repairs? And do you need an attorney, or is this a simple process?
Okay, great question. Um, if your landlord is doing something that or neglecting something that's vital to your living, let's say that there's contaminants in your water. Let's run that, and you brought it to attention, say, hey, Mr. and Mrs. Landlord, my water's coming out gray or rusty, that needs to be fixed. And they say, oh, we'll get to it when we get to it. So what you would need to do is write them a letter. Could be a form letter saying, dear Mr. and Mrs. Landlord, I brought to your attention that my water has rust in it, and asked you to fix it. You failed to fix it. Therefore, until you fix that, I am withholding my rent. So it's not anything that you have to go then run to the courthouse and put money into the registry. But you got to hold on to that money. So basically, you've told the landlord, fix it, and then you can get paid. So if the landlord doesn't fix it, you hold on to that rent. Now the landlord could say, okay, I'm going to try and evict you. You haven't paid your rent. Well, when you go to court, you give the judge that letter saying, look, judge, this is what's going on in my apartment complex. Bring a vial of the water and say, hey, look, this is what they expect me to bathe in, to drink in, to cook in. And I've told them that. Here's the letter I sent to them. And that is a defense. So they can't evict you. Now, let's say the landlord says, I'm sorry, I've been swamped. I'll get to it next week. They get to it next week. They fix it. You got clean water. Then you have to pay them that rent that you withheld. If you don't, then they can go and try and evict you. Now, the other thing that when we told about registry, if there's an eviction already in the pipeline for non-payment of rent, you have to deposit into the court registry at the court's office the amount of rent that they're claiming is due. Maybe you, for instance, on that case, you're withholding your rent, and they go to evict you. You got your rent. So that $500, that $1,000, you go down to the clerk's office after they file the eviction, and you say, I need to pay this on case such and such. And then that is your defense to the eviction, is I'm withholding my rent because my water is rusty, it's not drinkable. Take it down to Sears. I don't know if there's any Sears left. They would do a free water test. I think maybe Home Depot or Lowe's would do that for you. But look, here's all the contaminants in it. Here's the letter I sent. They have not fixed it, and that is a great defense. So that's actually kind of a nice protection for you in a way, is the court is not going to release that money to the landlord until you tell them that it's been fixed.
And not only that, sometimes you can also reach out to the code enforcement
Absolutely. Absolutely.
That's another way of having documentation of, things that have been identified as needing to be repaired, and they give the landlord a time frame on when to come into compliance. And so that's another way of you having those documentations, other than the documentations of you taking photos, because we have a lot of issues with people having mold in their apartments, or appliances not working properly. So bringing in code, bringing in that extra support of evidence is great also.
And here's the other thing to people need to be aware of is, and it's been brought to the forefront right now, that there is still racism out there. And if you see maybe one tenant, 2 or 3 tenants getting their mold remediated, but you're not, and you look different than them, that potentially is housing discrimination. If they're taking a preference over someone because of their national origin or their race, that is a potential fair housing violation. And that is an additional right that you have and you can bring forth. And I'll be honest with you, we've had cases like that where we had one where there was a sprinkler malfunction and 2 apartments were flooded. The white tenants got theirs fixed in 2 weeks, and it was going on over a year, and the African American tenant still had not gotten anything fixed. So it's horrible, and that's why the Fair Housing Act is out there to protect you, and that is very important. That is a civil right. It's out there for protection, and that's something that you can enforce yourself with our help. HUD, you can file discrimination claims right online. If you go to HUD.gov, fair housing, you can file it right online if you think you're being discriminated against.
Are there any other questions? Did anybody?
There was just a comment that today's United Way community conversation mentioned these issues that you're discussing as a possible call to action. That Ms. Bush just brought that to the audience's attention.
Thank you. So we're getting close. So did you want to talk about the key issues, just to pinpoint some takeaways that the viewers
Absolutely.
should listen to? So hopefully they have a pen and paper, because with me, if I write it down, then it's right there in my memory. So maybe they want to jot something down real quick. But I know this is recorded, and so it will be played again. But let's just, with all of the conversation that has taken place, let's narrow it down with some key points that they should walk away with.
Okay, and Marissa, do we have a slide with our helpline number?
Yes, we do. I'll put it up right now.
You can put that up too. Okay, there we go. Good. The biggest thing is, the takeaway I want people to understand is COVID has given you some extra protection, but Florida law is still Florida law. I don't want anybody to be taken advantage of by their landlord by trying to take the law into their own hands. We all are going through trying times. People have had drastic changes to their income level. Do not let a landlord take advantage of you from those self-help, like the commissioner said, shutting off water or changing the locks on you. If things like that happen, the number up there on the screen, you can call us. That is free legal advice. We can explain what your rights are. We might even be able to provide you assistance in court, depending on what our status is. We're concerned, Commissioner, that we've been calling it a tsunami, that once all these moratoriums are lifted, that the legal issues are just going to come swamping in, and so we're trying to lay the groundwork ahead of time. I don't want people to get taken advantage of. If you have lost your job, if you've been furloughed and you're behind on your rent, it's scary, I know, but be proactive, be your advocate, start thinking of plans, what you can do once this moratorium is lifted, because if July 6th comes and that moratorium has not been lifted, chances are you're going to get that 3-day letter, and then the clock is ticking on you. So I want you to have a plan in place beforehand. If you know you're going back to work and you know you might be able to make some payments on your back rent, get that plan in motion now. Don't wait until the eviction's been served on you, because at that point in time, the landlord's going to say, look, I've had to pay a lawyer to file this. I had to pay filing fees. It's just going to make the costs go up. If you have a mortgage that you've fallen behind on because of COVID, then reach out to your mortgage holder and start that dialogue with them. You don't want a foreclosure action filed against you. You want to stay in your home. You want to work out a way that you can continue living in your house, making the mortgage payments. Once again, the forbearance. Get whatever you haven't paid, put on the back end of your loan. If you are unsure, if you think something's wrong, but maybe I didn't cover it here today, the commissioner's office isn't sure as well, call the helpline, log on to our website that's up there on the screen. You can do an online intake even where they can get all your information. We actually have the ability now to do live chats with a lawyer. When you call this number, this 1-800 number, a lawyer will be answering the phone. You're not talking to a paralegal or receptionist and then they're going to schedule something. A lawyer is answering that phone, and he'll be able to take you through the steps, answer your questions. If there's something you need to file, something you need to do immediately, they're going to let you know. So it's a great resource for people, and we just want to help as many people as we can.
Great. So, I'm gonna have I guess some final comments, and I think what's just in my mind to say to the viewers or listeners is it's often said that ignorance is expensive. How expensive just depends on what you do not know. So it is vital that when you know a situation is coming, try to get as much knowledge as possible on what it is that you need to do, what your options are, because it could cost you being put in a position where you have an eviction that's going to follow you for a very, very long time, or a foreclosure. So just remember that there are resources out there, and you have to take advantage of those resources that have become available. And like I said, and you've said it, Attorney Hussey, is that, because of COVID, there are things that the government has put into place for you, resources. So, and this is one of them. Call, ask the question. I've heard there's no such thing as a dumb question,
Yep.
So just ask if you don't know, but we don't want to see you in a position where you're out of something that potentially could have been solved, but because of the lack of knowledge, you're in that situation. And so that's one of the things that I wanted to leave with the audience, the viewers, the listeners, is that ignorance is expensive. How expensive just depends on how much you do not know. So it is up to you to educate yourself, to ask the questions. The people are there. The legal minds are there. And I just want to say again, thank you for the legal services of Mid-Florida for the work that they're doing. There's so many attorneys who have volunteered their time. And thank you again, Attorney Jeffrey Hussey, for just spending time with us, trying to educate our community. We really, really appreciate it.
Well, I appreciate you having me. And one other thing I'll leave you with is that number 211. That's a gateway to get you into the system if you need help that's maybe outside the legal realm, but you need emergency housing or things like that. That is the number to call.
Thank you.
Thank you for having me, Commissioner.
Bye-bye.
Bye-bye.